Good afternoon. It's Thursday, February 16th, 2023. Call this meeting of the Senate Elections Committee to order. A quorum is present. And by the way, just so that we all know that we do have to have a quorum before we do anything, and we do have a vote that has to be taken right away. So if you can, come in and check in so that we can get a quorum as soon as possible and we aren't using up time wasting time with people. But we have three bills on the agenda today, and the first one that we're going to consider is Senate File 1508 with Senator Mitchell. And since this is the first committee, Senator Mitchell, you have an A2 author's amendment. Would you like to move that amendment?
Yes, thank you. For the record, I am Senator Mitchell, offering Senate File number 1508, and I would like to offer the author's amendment, which is a delete all, but it doesn't actually change much language. It is because a couple committee members kindly came to me with suggestions, and so we'd made a couple different incorporations, and it was just easier to put it into one delete all.
Thank you. Senator Mitchell moves the A2 amendment to Senate File 1508. All in favor, say aye. 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 All opposed, nay. The amendment is adopted.
Thank you.
Senator Mitchell.
Thank you, Mr. Chair. So I would say this is a pretty simple addition to what are our non-campaign expenditures. There's three categories that are covered by this. One is if there is a recount, and particularly, I haven't gone through one, thankfully, but even if it's paid for by the state or the county, some people incur legal expenses, or you might have staff that needs to stay on during the process of the recount. So it adds that into the category of non-campaign expenditure. We have another section that changes, just adds monitoring expenses to if someone needs security related to an election or being an elected official. And then also we have if someone's campaign property, specifically thinking of lawn signs, but it could be someone vandalizing a billboard or something else, but that if you have to replace items that you've already purchased on campaign expenditures, then it is a non-campaign expenditure if you have to replace it due to basically some form of malice. So those are the three items that we're looking at with this.
Thank you, Senator Mitchell. Do we have any amendments? Senator Rest. Use your mic, please.
You missed the one of the running a transition office.
Oh, yes. Thank you, Senator. Yes, there is one also for a 3-month period to basically the gap from election to a lot of us get sworn in, you know, at the start of January, for example, for up to 3 months to be able to run a transition office as needed.
Thank you, Senator Rest. Thank you, Senator Mitchell.
Hey, I do have one more question.
Senator Rest.
So, Senator Mitchell, particularly with that one I just brought up to you, right now, the expenses of running a transition office are campaign expenditures?
There's
Senator Mitchell.
Thank you, Mr. Chair. Right now, people are caught in essentially limbo because it's not a campaign expense and you don't have your budget yet for your office. So you don't have the ability to hire a staff.
So
Senator Rest.
I guess at some point, Senator Mitchell, Mr. Chairman, would like a little bit of clarification for that, because at least the running for governor, there's a transition office that is set up for a new governor in the Capitol building on the 3rd floor if the incumbent doesn't win. And I think maybe the state pays those costs, but I can see Mr. Campaign Finance coming forward, and maybe he could at least give a little bit of light on maybe which costs are covered by the state, and as you're suggesting, there are other kinds of costs that the candidate themselves would, and his or her campaign committee would cover that do need to be classified.
Thank you, Senator Rest. Mr. Sigurdsson, can, I know he's articulated this to me before. Mr. Sigurdsson, please identify yourself for the record and let us know what you're thinking.
Thank you, Mr. Chair, committee members. My name is Jeff Sigurdsson. I'm the Executive Director of the Campaign Finance and Public Disclosure Board. The additional non-campaign disbursement on line 3.1 is based on an advisory opinion that the board has issued to two different governors, Governor Pawlenty and Governor Dayton, because typically campaigns run up against the spending limit at the end of the election, and so they need to use committee funds in this category. So.
Makes good sense.
Mr. Chair, if I could add?
Senator Mitchell.
It would also be, so for example, me being a new senator with a new LA and everything else, it would have been delightful had I had those funds to even be able to get my person in the office maybe a week ahead of time, if that would have been allowed. Because, for example, we have new senators that didn't get an intern, because usually that's hired by the LA, and they weren't in the office yet, and the LA wasn't in the office yet, and now they're struggling without interns. So it would also potentially be a situation where if someone just really felt like they needed a little gap bridging so that we weren't all starting on January 3rd, that they could do that as well.
Mr. Chairman,
Senator Rest.
Senator Mitchell, this is only for a statewide office, not for a legislative office.
Mr. Chair, if I could address that.
Mr. Sigurdsson.
Senator Rest, you are correct. Again, this is based on the advisory opinion that was issued by the board. The advisory opinions are only safe harbor for the candidate or committee that asked for it, and so the board wanted to move these into statute. If there was interest in moving this to make it for all constitutional and legislative candidates, then a change in the language would be necessary.
Mr. Chairman and Senator Mitchell.
Senator Rest.
I would suggest as this bill moves forward, it's included in a larger bill, that you consider making it eligible for members of the Senate and the House of Representatives for the very reasons that you just mentioned in terms of your own experience.
Yes, and I apologize, that was
Senator
my
Mitchell.
misreading.
Yes, Senator Mitchell.
Thank you.
Okay, thank you. Senator Grant.
Thank you, Mr. Chair, and Senator Mitchell, and Senator Rest, thanks for making sure it's clear that it is a state constitutional offices, and so to me, that really is where the only need is, and so the caucuses have opportunities, right, to bring staff on when they choose and to budget for those things. As individual members, we've been through those transitions, and I really don't see a need of what we'd like to do. We've gotten by just fine for decades and decades. So I think the offices that have significant transition, which are our constitutional offices because of the scale and the scope and the time, but as a legislator's been through it, I don't see any practical need to include the Senate and or the House members in this. So I would hope you don't make that adaptation or change. Thank you.
Thank you, Senator Krantz. Senator Rest.
Well, Mr. Chairman and Senator Coran, if caucus makes a contribution in kind to you of legislative assistant or secretarial help, you have to report it as an expenditure. And if it's going to be, and there's some candidates who will be up against the expenditure limits, and so I disagree very much with that opinion.
Mr. Chair.
Senator Krantz.
Thank you, Senator Rest. Senator Rest, I wasn't implying that the caucus is going to make the contribution to any individual candidate, but the ability to prepare the candidates for serving once elected on January 3rd or whatever our begin date is. We've been able to manage for many, many decades with the current situation or the current set of statutes. To me, it's just an expansion of another need of resources that are unnecessary. So, and I didn't mean to imply, if I did, that the caucus is going to contribute to anybody. But as a caucus as a whole, as they're formulating, when they bring staff on, that's of course that all budgetary, and they have many opportunities to prepare our staff, us as members, and and everybody for the beginning of a session.
Senator Rest.
Well, again, Senator Coran, I disagree with that with regard to people not like yourself or a bunch of other of us with a brand new elected person who's not allowed to hire anybody against the Senate budget, for example, until that person can't start until January 3rd this year. And it seems to me that that puts them at a great disadvantage to those of us who are ongoing incumbents. And if they have the funds to use from their campaign to hire a temporary staff person before we begin on January 3rd, it seems like to me it's a very legitimate use to call that a non-campaign expenditure. But we can agree to disagree.
Any other questions? Senator Anderson.
Thank you, Mr. Chair. Mr. Sigurdsson, how will this delete all amendment expand our campaign guidelines going forward?
Mr. Chair, Senator Anderson.
Mr. Sigurdsson.
Again, this is the non-campaign disbursements, so it's merely adding categories of expenditures that won't count against the spending limit if the candidate has signed the public subsidy agreement. I'm sorry, I'm not sure if I'm following your question, so maybe you could focus it so I can understand what you want me to address there.
Senator Anderson.
Thank you, Mr. Chair. Mr. Sigurdsson, the present plan right now has an outline as to what we can or can't do for non-campaign. How does this expand those non-campaign guidelines for candidates, whether they're Senate, House, state, or local government, whatever the case might be? Mr. Sigurdsson.
Mr. Sigurdsson.
Mr. Chair, Senator Anderson, the one on line 2.16, the cost of candidates, principal campaign committee in support of the candidates' participation in a recount. Again, that's based on an advisory opinion that the board has already recognized that that's a legitimate use of committee funds. Since the election's over, it shouldn't count against the spending limit, but it's certainly appropriate for funds raised for a political purpose. So to the extent that it's a new category, I don't believe it is. The board would recognize that for any candidate that asked that advisory opinion, but rather than have them ask the advisory opinion so that they have safe harbor that applies, we're just moving it in the statute so that it's there for everyone. But frankly, the board already recognizes that. The same with the transition office. Again, that's been provided by the board to two different governors, and if it would have occurred this year, it certainly would have been extended. Again, this is just putting it in place so we don't have to go through an advisory opinion every time that occurs. The one that, and the modification to The number 29 on line 2.28, that is an existing one. It's a modification, but that, of course, is an existing non-campaign disbursement. The one that's new is the one that you see on line 3.3. That's not a board's recommendation, but obviously Senator Mitchell could address that. But that would be the one new category.
Thank you, Senator Anderson. Thank you, Mr. Sigurdson. Senator Grant.
Mr. Chair, thank you, Mr. Chair, and Senator Mitchell. On 3.3, the cost to repair for replaced or damaged campaign property. The scenario kind of describes, damage effaced, whatever that could be, a sign or which is referred here, but it's not limited to campaign signs, but doesn't appear to be anything besides a candidate document that determines that these costs are verifiable. And so those types of activities wouldn't currently be required to be reported as far as backup documentation as they're not today with the Campaign Finance Board. To me, I think this is, again, an unnecessary component because I think it just moves more qualified campaign expenses into the non-qualified, indirectly increasing the limit on the cap, the qualified spending limits. And I thought the theme here was to limit, spending and make sure we know where all it is. I think this just allows the opportunity to move computer hardware, PCs, laptops, whatever it is that you choose to replace and not incur those at a qualified expense, whereas whatever else falls under qualified into non-qualified. So again, I think it's an unnecessary adjustment that's proposed in this bill.
Senator Mitchell, any reaction?
So there does have to be some form of documentation. We kept that a little bit loose because, for example, I literally had someone running a route on my lawn signs when I was running this past session. Like it was a loop. They would run through the town every weekend. I didn't file a police report. I had emails with the city. So, we kept this a little because not everyone wants to file a police report every time, but I also had documentations that people would email me. My lawn sign got hit again. So we did have a paper trail. We're merely asking people to keep the paper trail. Photographs, it was actually Senator Rest who described a situation. She would do a better job describing it than I would about where hers were defaced with essentially being colored on. I was hoping she'd be able to bring that picture because they sounded like they were kind of entertaining. But there's not always going to be a police report for everything. We're just asking people to keep the relevant documentation, but we do. I think most of us that have been doing this, if you already have a budget and you've already spent your money, and then you're having to go back and spend more money potentially on things that, because of some act of malice, you shouldn't have to spend those campaign funds twice. I would also say a lot of people, and I was one of them, this wasn't an issue because I never hit any of the markers. So this is really going to be in those tight campaigns, especially the lawn sign issue, where everyone is spending up to the limit, and in a tight campaign, unfortunately, might also be the situation where there is more theft or vandalism or whatever else going on.
Good. Senator Suzinski.
Thank you, Mr. Chair, and I apologize I was late, so just say we've already covered this and I'll talk to you later, Senator Mitchell, but I really did feel like it was a disadvantage of the new freshmen, both parties that didn't have their LAs until the day of the first session, and that's why, how in this bill is that, where did that, maybe it was one of my colleagues' question, I don't know, but I'm very interested in trying to fix that and maybe allowing freshmen to have somebody start on December 26th or whatever may be the case. So how did that come up in conversation in the bill, and feel free to say, I'll talk to you this later because we already covered it, but I'm really interested in this topic. Thank you, Mr. Chair.
Senator Mitchell.
Thank you, Mr. Chair. So it came up in terms of a question that was asked, you know, I, of course, am working on this with someone from the House, and I had missed the constitutional element. So my implication that it would have also applied to us, it doesn't as written currently, but our discussion was expanding that because of the fact that, as I said, there were a number of us freshmen. I started getting meeting requests the day after the election. I had taken so many meetings. My foot surgery was December 16th, and I think I'd probably taken at least a couple dozen meetings in that 1 month gap without having an LA or anyone to help. There was no one to help us hire interns. Some people ended up without interns. So there is a discussion that as we carry this forward and it's hopefully held over, that we might add that consideration.
Thank you, Mr. Chair. So what you were thinking at some point to, after, on line 3.1, after state constitutional office to, or amend that to say senators and House members as well?
Correct.
Okay, thank you. Anything I can do to help in that would be, I'd be more than happy to assist you in that.
Thank you, Senator Swazinski. Now it's time to add my own personal experience. My committee administrator here could not start until the first day of session. And part of that was because there was no allowance for people to be hired early. My first term was in January 2007, and I was able to hire an LA to start on December 27th because the caucus that was in charge did budget for that, and I was able to do that. So I wasn't even used to having an LA not be hired, and then 2 successive years when and budgeted for that. You can't hire a person, or you can hire them, but you cannot have them start work until the baton is handed over to the other party. And so that has been my situation at least twice. One time, because we had a hiring freeze that started the second week of June, and I had an LA that went off to work on a campaign, and I could not hire a person to start. I could not have that person start until the first day of session in January, which was a major, major problem for me. And I appealed the decision of the hiring freeze, but was denied that. So I really strongly feel that we possibly should change something the way the caucuses handle it, or have this kind of thing, at least to our ability to use our campaign funds, non-campaign funds, to have someone that will help us get the transition done. So now, Senator Marty.
Thank you, Mr. Chair. I came in late on the discussion as well, but 2 points. One, I think it's the Senate should fix the problem with doing it. Some of our Senate staff are allowed to begin before January 1st. We ought to fix it here. I don't think campaign funds are the best way to be funding staff for the Senate. That's an issue we should be dealing with this year in the legislative budgets. But the other thing is for a transition office, and again, for the constitutional officers, I know sometimes gubernatorial candidates have had to rent office space and everything else. And I assume that's worth itemizing in here, but I will point out that on the delete all line 22 of the first page, already you can use campaign committee expenses for the expenses of serving in public office. And I would argue that a lot of such, if you had 3 days earlier you wanted to start or pay somebody for a few hours to help with that, I would argue that that's covered under that. But fundamentally, I don't want to think we need to get into hiring transition offices for legislators, but we can't have it. It's inexcusable to have people starting the first day of session when everything hits them and so on. But so I'm not sure if you need that for legislators, because I think it might already be covered under 10. But on the lawn sign, stolen or lost, I think point out that the other one, which I was familiar with earlier, that we have if there's defective campaign materials or something and it's destroyed and not used, you can replace that as a non-campaign expense. So, I mean, the lawn sign was obviously related to that and probably worth clarifying.
Yeah, thank you, Senator Marty. You may have missed that early in our discussion, the legislators were not included in the bill and still are not.
Right.
And we did have a suggestion to add it if this bill goes on to other committees. So,
Mr. Chair,
Senator
request a
Grant.
roll call.
sorry, Senator Cranberry, we're going to be laying this over. Yeah. So, thank you. And with that, this bill is laid over. Senator Anderson.
Was there a fiscal note request made on this bill?
There was not.
No, sir.
Does it need,
There is no physical cost to the
Mr.
language?
Chair.
it's no cost?
Mr. Chair and Senator Anderson, there's no cost to the state on this. It has to do just with what a candidate can do with campaign funds. So there's no effect on the state about what those would be, what qualified expenses there might be there.
Thank you.
Thank you. Okay, with that, we will lay the bill over, and we'll go on to the next one, which is Senator Westlin, Senate File 1191.
Mr. Chair,
Senator Anderson.
is this bill going to be laid over also?
Senator Anderson, no, this one will go to Judiciary.
Judiciary? Thank you.
Senator Westlin has Senate File 1191. And let's see, I see you have an author's amendment as well.
I do,
And is this your first committee? Okay,
yes.
so it is an author's amendment, and it's the A15. Senator Westlin moves the A15. Oh, I understand that, should we amend it before? Okay, we have a slight amendment to this, and Senate Council will provide those words.
Thank you, Mr. Chair and members. Looking at the A15 amendment on page 14, line 11, the word either should be deleted. So it will read absentee ballot as provided by sections, and then the rest remains the same.
Okay, Senator Westlin, is that a friendly amendment to your amendment?
Yes, I believe that's in the nature of typographical error.
And so Senator Westlin moves the A15 amendment to her Senate File 1191. And this is an author's amendment. Mr. Chair, could you have that repeated? Okay.
Thank you, Mr. Chair and members. On the A15 amendment on page 14, line 11, delete the word either. So it will say absentee ballot as provided by, and the rest remains the same. And Senator Westlin, if she chooses, could incorporate that into the adoption of the A15.
Thank you.
Thank you, Senator Anderson. Back on the author's amendment. All in favor, say aye.
Aye.
All opposed, say nay. The amendment is adopted. Senator Westlin.
Thank you, Mr. Chair. So members, we were trying to provide you as much information as possible about this bill. And it has been a work in progress. There were a couple of additional technical corrections that Ms. Stengel identified. And in order to make this easier for everyone, what we did is we incorporated all of the separate amendments that you may have seen in your email last night into just this one single delete all amendment. This is the Secretary of State's administrative bill. And I think that the best way perhaps to start here would be to have Ms. Stengel do a walkthrough of the bill. And then we'll have Ms. Freeman can come and present on the bill as well as our other testifiers.
Thank you, Senator Westlin. Senate Council.
Thank you, Mr. Carlson, Senator Carlson and members. Walking through the A15 amendment, as I go through, I'll indicate which sections are new as opposed to the version that was introduced, so you can see what has been added. Starting on the A15 Amendment, Section 1, on page 1, this allows the Secretary of State to use the SVRS statewide voter registration system to prepare a ballot and mail it to the participant in the Safe at Home program. Section 2, starting on page 1, carrying over onto page 2, allows the Secretary of State to provide features on the online voter registration website that allows it to interface with third parties to allow individuals, to facilitate individuals submitting their voter registration. Section 3 has to do with Election Day registration, and it amends the definition of residential facility as it pertains to vouching. And the additional facilities are assisted living facilities, residential treatment facilities, and adult foster care facilities are added to the list of residential facilities that can be used for vouching for people that live in those facilities. There are several sections throughout this bill where it changes the phrase resides to maintains residence, and I will just sort of flag those as we go through. Section 4 is the first of those sections that makes the change to maintains residence. Section 5 on page 6 is another maintains residence. Section 6 is the first of several sections related to timing of absentee ballots. One of the later sections will allow absentee ballot envelopes to be opened and processed 14 days before the election instead of 7. So there are several changes throughout the bill conforming to that main change, and Section 6 is the first of those sections.
Senator Rest. Senator Rest.
As we go through, could we have like a reason given for that change? I mean, why go to 14 days from 7? Where did that recommendation come from, and why is it needed? I'm not challenging it, I just want to understand.
Mr.
Senator Rest, this is primarily an agency bill, so if we want to stop and do that, we can do that.
Well, we are changing a lot of dates in here, time periods. I've spoken to Senator Westlin about it. I'm not challenging it, I just want to understand why things are going to take longer or need more time. And certainly the Secretary of State's office should be able to tell us.
Mr. Chair,
Senator
Senator
Weston.
Rest, I want to make sure that this goes through in a process where it makes sense to people, and if it makes sense as we're going through, if someone wants to ask a question as we're doing the walkthrough, I'm fine with that. It may be easier to do it that way. Again, I just want to make sure that everybody's tracking, first of all, with the changes that are being made, and then have the opportunity, Ms. Freeman could certainly interrupt momentarily to explain what the purpose of the language is. Again, we're trying to do this as efficiently as possible, but want to make sure that people are fully tracking and understanding the changes being made. So I'm open to that if that's the will of the members of the committee.
Senator Rest, what's your pleasure? Would you like to have that?
I'm just curious about why a change like that is made. I'm not challenging it, I just want to understand, that's all.
We understand that. We just want to know whether you want to have Ms. Freeman answer the question.
Seems like to me, Mr. Chairman, Senator Westlin, if we did it as we're going through, then we don't have to go through it again, because otherwise we have to go back and go through it section by section by section to explain what the meat of the bill is. So why not do it the first time around?
Ms. Freeman, could you step up to the mic, and in case we have more questions, maybe hang out at the testifier table. Please identify yourself for the record and perhaps answer this question.
Thank you, Mr. Chair and members. Nicole Freeman, Office of the Secretary of State. This particular change that Ms. Stengel has mentioned extends the time period for when absentee ballots can be opened by a ballot board. In 2020, there was a 1-year change to allow additional time for local jurisdictions and their ballot boards to process these ballots. Since 2020, we have heard repeatedly across the state from large counties and small counties that this flexibility was very helpful. It wouldn't require them to start, but would allow them to start to do this work 14 days ahead of election.
Thank you, Mr. Chairman.
Senator Rest, no follow-up?
Mr. Chair,
Senator Grant.
along that line, so Ms. Freeman, so a lot of things are helpful, but are they completely necessary? And so did anybody not meet their, with the traditional or the previous 7-day counting, did anybody not meet the deadline?
Ms. Freeman.
Thank you, Mr. Chair and Senator Cran. So thus far, I am not aware of folks who didn't meet the deadline. The deadline is, I believe, 24 hours right now. It's 24 hour, within 24 hours of election night. There were several counties who were counting ballots through election night and into the very early hours of the morning. So again, this allows them the flexibility to start this work earlier, should they like to do that.
Mr. Chair, if I could, as we have been.
Senator Westlin.
First of all, actually, I would like to acknowledge staff. Ms. Stengel and Ms. Frazier have worked not only with the Secretary of State's office, but with the city and county organizations who have weighed in on the Secretary of State's administration bill. And some of the suggestions have been, we've had feedback from them as regards to some of these changes. And so the question of has it happened, I understand the nature of the question, but I think that our local folks are asking for a little more leeway on some of these deadlines.
Senator Mitchell.
Thank you, Mr. Chair. Senator Westlin, Ms. Freeman, I would guess that if there are times when counties are scrambling to count through the night or bump up against these deadlines, that I know counties often hire election judges to come in extra and help with this work, that there might be a situation, and a lot of this cost is borne by the counties, that they're now paying overtime to do some of these things. So would extending the time somewhat possibly alleviate that?
Senator Westlin. Or Ms. Freeman, do you have a response on that?
Sure, Mr. Chair and members. Yes, I think that administratively it would allow them to, like I said, extend the work during the business hours during those 14 days. And I did just want to clarify that these allowances, starting in Section 6, allow them to open and process ballots, but the counting is not done until election night.
Ms. Stengel, maybe you could continue.
Thank you, Mr. Chair and members. I will also note that all of the provisions extending from 7 to 14 days are new in this amendment as opposed to the introduced version. There's a section that isn't in the A15 that was deleted, and that had to do with deficient registrations. That takes us now to Section 7 on page 6 with the presidential nomination party list, and this requires the Secretary of State to give separate lists to each major political party chair of only the voters who voted for that or who selected that party. Section 8 on page 6 is another maintains residence section. Section 9, starting on page 7.
Mr. Chair.
Senator Anderson.
Ms. Stengel, or to the testifier, what's the significance of putting in maintains residence versus resides?
Mr. Chair.
Why the change?
Senator Westlin.
I'll give it a shot, and she's my backup. But my understanding is that the term residence is a defined term. The term resides is not. And so this was changed in order to have the new language actually refer back to a definition and statute. And so that's why it says maintains residence, because the term residence has a statutory definition, but the term resides did not. Do I have that right?
Mr. Chair.
Senator Anderson.
Senator Westlin, what is the definition of residence?
Ms. Freeman.
Thank you, Mr. Chair, and Senator Anderson. Minnesota Statutes 200.031 defines voter eligibility based on where a voter maintains residence. And And that statute that defines voter eligibility does not define the word resides. And so that's why we have changed or made this shift, which started back in 2004. And so this is to try to conform language to all refer to voter eligibility where someone maintains their residence or maintained residence.
Follow-up, Senator
Thank
Anderson?
you.
Thank you.
Mr. Chair?
Senator Grant?
Ms. Freeman, with that, so the definition of maintains residence is what? I think we clarified that resides wasn't defined, but in the statute, just quickly off your head, what is maintains residence?
Senator?
Maintain a mailing address, actually live in the facility? Take your time.
Ms. Freeman, when you're ready.
I'll have to look that up.
Thank you.
Perhaps council can help us with that.
Mr. Chair and members, I think, Ms. Freeman can correct me if I'm wrong, but I think she mentioned earlier statute 200.031, which is the determination of residence, and there are a list of 13 different factors that are looked at when determining where a person resides, and that can be where their home is located, where they sleep at night, where their families are. It's a whole variety of factors to look at to determine residence.
Yep, so I did pull up the
Senator May.
statute.
Senator Westlin.
Sorry, Mr. Chair. 200.031, and it's entitled Determination of Residence, and it says residence shall be determined in accordance with the following, and then it says residence of an individual is a number of things. And so again, the change made is conforming language because maintains residence goes back to the statutory definition in 200.031.
Thank you. So in other words, the maintains residence is more precise than resides. Am I hearing that correctly? Senate Council?
Mr. Chair and members, as I understand the Secretary of State's explanation is that maintains residence is more consistent with the existing statutory language on how you decide where somebody lives. And that's the phrase in the statute is determination of residence.
Thank you. Please proceed.
Thank you, Mr. Chair and members. We are at section 9 on page 7, and this has to do, the change is actually on page 8 for incomplete voter registration. The status is changed to challenged instead of incomplete, and that corresponding change is talking about clearing the challenge instead of completing registration. Section 10 on page 8 is a maintains residency change. This is quite a long section, so that takes us to page 10. Section 11 is another maintained residency section. Section 12 on page 10 is a new section in the DE, and this has to do with challenges that are made before Election Day. So this allows an individual, a voter, to file a petition with the county auditor challenging somebody's eligibility to vote. And this sets forth a process where the petition is filed with the county auditor reviews it. There are specified reasons for dismissal, and then if it's not dismissed, then there is notice to the voter, and then there's a hearing and appeals process to determine whether the voter status should be challenged in the SVRS. That
Mr.
takes
Chair.
it-
Senator Anderson.
Thank you, Mr. Chair. So in challenging, we're still talking where the next section talks about maintains residence. Were there, Ms. Freeman, in the last election, situations where a resident or a person that voted, their residence was challenged in the election?
Ms. Freeman.
Mr. Chair and Senator Anderson, yes, I do believe there were, under this section 201.195 about petitions, I do believe that there were challenge petitions that were filed prior to Election Day last year.
And Mr. Chair.
Senator Anderson.
Ms. Freeman, how many were there?
Ms. Freeman.
Chair Carlson and members, I do not have that number off the top of my head. It's a number that would be located with the counties. The counties don't report that to the Secretary of State's office. The only time that our office is involved is if there is an appeal.
So, Mr. Chair,
Senator Anderson.
Ms. Freeman, you did get a list, or you did get confirmation from the counties that they had challenged residences in them. I'm taking from what you're telling me that that's the case, even though you don't have that information.
Ms. Freeman.
Thank you, Mr. Chair. Yes, we did hear about this happening from the counties.
Mr. Chair,
Senator
Ms.
Anderson.
Freeman, do you do any investigation in that realm of challenged residences?
Ms. Freeman.
Mr. Chair and members, so voter registration data and eligibility is determined by county auditors. And so our office maintains a statewide voter registration system that sort of holds all of that data, but those determinations of eligibility are made at the county level.
Thank you, Senator Anderson. In fact, I think that the extended response is that that's turned over, those complaints are turned over to the county to investigate. And it's the county that determines the answer to those complaints. And I think we're talking about pre-election challenges in this particular section. They're talking about petitions supposed to be filed at least 45 days before the election. So, Senator Matthews.
Thank you, Mr. Chair. For Ms. Freeman or Ms. Stengel, the new language in Section 12 has timelines now with cutoff dates at 45 days or 10 days if a registration was updated within the last 60 days before an election. What's current statute today? Are there any time parameters in current law today?
Ms. Freeman.
Thank you, Chair Carlson. There are currently no, you can, as you can see in the bill language, there are not currently timelines for when these petitions can be filed.
So,
Senator
Mr. Chair, then I need to give the follow-up why question. What's the need for why this was brought forward? This feels going exactly in the opposite direction of openness and transparency, and there could easily be a myriad of reasons why this would need to take place much more closely up to an election day. So why is there an arbitrary cutoff period here?
Ms. Freeman.
Thank you, Mr. Chair. There is still the process on Election Day. So putting timelines in place is to ensure that these issues can be resolved prior to Election Day. So a determination can be made by the county, or if it is appealed by the Secretary of State's office. I would also say that there is still a challenge process on Election Day where someone can challenge a voter's eligibility on Election Day. An election judge can do that, as well as the challengers that are within a polling location. They can file that challenge, like I said, on Election Day. And I'm also told some of this, the timelines as we were developing this, we looked at other states and the process that they had in place to look at timelines that exist across the country too for this process.
So, Mr. Chair.
Senator Matthews.
And Ms. Freeman, then you're saying that under this language, if enacted, and someone walks into a county facility 44 days before an election day to a registration not updated, the county official should tell them, sorry, you have to take your complaint, go back home, wait 44 days, and go back to that polling place, which is over a 6-week time period. Is that what you're telling me is going to be the new status quo?
Ms. Freeman.
It would preclude them from filing a petition of challenge. It wouldn't preclude them from bringing this to the county attorney's office or local law enforcement for investigation if they wanted to go that route. Those avenues would still be available.
Thank you. Ms. Stengel, please continue.
Thank you, Mr. Chair and members. On page 12, section 13 is a maintains residency section. On page 13, section 14 is a maintains residency section. Section 15 specifies that at a caucus, they don't have to give out a ballot for a governor preference if the governor does not appear on the ballot, so limiting that option, that requirement to every 4 years. On page 14, sections 16 and 17 work together, and this allows an emergency response provider or a utility worker to use the UOCAVA absentee voting process if they are deployed during the period leading up to an election. Sections 18 and 19 on this page work together. There's sort of a reorganization. The new language you see in section 18 has been stricken from section 19, and then section 19 has been reorganized, and there's not a substantive change in either of those sections. Section 20 on page 14 is a new section, and this is another change from 7 to 14 days before the election. Section 21 on page 15 has to do with agent delivery of ballots. Sorry, making sure I have the right section here. Yes, and this has to do with, it increases the number of facilities that can use this process, including now using assisted living services, veterans' homes, or shelters for battered women. Yes, thank you. Yes, thank you, sorry. My mistake, this is not agent delivery, this is absentee voting in healthcare facilities, which is a different thing. So yes, this is voting in healthcare facilities, so it adds those lists of facilities to this process. Section 22 expands the time where the voting in healthcare facilities can happen from 20 to 45 days. This is a new section. Section 23 is a new section, and this is the agent delivery of ballots. And it requires the request for an agent and the delivery of the ballot by the agent to be done by 8 p.m. on election day, which allows for more time for that to be completed. Section 24 is another new section. This is another change from 7 to 14 days. That takes us to page 18, section 25. This is another new section that changes 7 to 14 days. On the next page, section 26 is also a new section that changes 7 to 14 days. Section 27 is a maintains residence section. Section 28 is a new section, and it works in conjunction with the next several sections, amending requirements for filing multiple affidavits of candidacy. So you'll see some stricken language here that would allow certain candidates for soil and water conservation districts and some other very local things to be able to file more than one affidavit of candidacy. So that language is stricken here and reinserted in a later section. Section 29, also about affidavits of candidacy, says that if a candidate or their campaign doesn't have an email address, they are not required to provide one on that form.
Senator Rest. Senator Rest.
Mr. Chairman, this is a really, really technical thing, but I don't understand why and I'm looking in that section, but at the A4 minute, why does it say electronic mail address on one line and an email address on the other line? Isn't that the same thing? And maybe moving forward, Ms. Freeman, don't do it now, but make them the same words if they mean the same thing. Thank you, Mr. Chairman.
Thank you, Senator Rest. We have that noted? Thank you.
Note to self.
Okay. Senate Counsel.
Excuse me. Thank you, Mr. Chair. On page 21, section 30 is still about the affidavit of candidacy. This one has a change for judges, and this is a conforming change to current law, but requires them to state that they will not turn 70 before the beginning of their term. There's also a maintains residency change. Section 31 on the bottom of page 21 is the new section that has to do with filing multiple affidavits of candidacy. So it allows certain people to submit multiple affidavits of candidacy. And that is listed out there in the acceptable combinations. On page 22, section 32 is a maintains residency section. Section 33 on page 23 is a new section, and this has to do with write-in votes. This allows a city or town to adopt a resolution that specifies when they will count write-in votes. So under current law, they have to count every single write-in vote. This would allow them to specify under which situations they will count write-in votes. It also requires a candidate for president who files a request to have write-in candidates counted to include the name of their vice president. Section 34 on page 24 specifies that the vacancy and nomination for partisan offices does not apply to a vacancy and nomination in a federal office. Section 35 is a new section, and this requires the county auditor to notify the Secretary of State when polling places are combined or when combined polling places are separated. Section 36 on page 26 has to do with designating polling place locations. So essentially, a local government adopts a resolution establishing polling places, and that remains in place until it is changed by ordinance or resolution or for some other various reasons. On page 27, sections 37 and 38 are both maintained residency changes. Section 39 on page 28 removes the geographical restriction on using mail ballots. So now, under this language, a town of any size anywhere in the state or a city with fewer than 400 registered voters anywhere in the state may use mail balloting. Section 40 is a new section that includes both maintains residency and a 7 to 14 day change. On page 30, section 41 has to do when there's an overlapping school and municipality jurisdictions, it's allowed to have a ballot on the mail, a question on the mail ballot. And there's also a 7 to 14 day change in this one. Section 42 on page 31 is a new section, and there's some updating of language there, but the main change is towards the end and specifies that challengers must not converse with the voter. And it eliminates the ability for the challenge to speak to the voter to determine residency. Section 43 makes a couple of changes. One is it eliminates the cap on the number of people a voter can assist in voting, and the other will allow a candidate to assist a voter in filling out a ballot. On page 32, there are some changes to the summary statement at the end of the night for an election. It must include the number of election judges that worked in that precinct and the number of voting booths in the precinct on election day. Section 45 is a new section, and this has to do, there's some updating of language, but the main change is on page 33, line 18, specifying that if envelopes were opened by a proper authority pursuant to a court order or statute, then they must be resealed, and those are absentee ballot envelopes. Section 46 is a new section, and this allows the canvassing board to direct official images of challenge ballots can be made public. In the underlying bill, there was a section on the canvassing board declaring the winner. That was in a bill earlier this session, so that section had been eliminated. Section 47 has to do with when a county canvassing board determines that there was an obvious error, and it requires the county canvassing board to instruct the county auditor to apply to the district court for an order about that error. Section 48 on page 34 requires the city offices and school district offices to be put on the state and county nonpartisan primary ballot. Sections 49, 50, and 51 work together, and this changes the timeline for a special election when the legislature is in session for a legislative vacancy, and it increases the timeline by 2 weeks. Section 52 on page 35 is a maintained residence change. Section 53 is a new section, and when a governing body for a local election has different polling place hours, they must notify the Secretary of State. Section 54 is the same change, only for school districts. Section 55 is a maintains residency change. Section 56 on page 37 is a maintained residency change. Sections 57 and 58 on page 37 require city or municipalities and counties to continue using electronic voting systems once they've started using them. On page 59, there is a new section relating to cast vote records. So what is public or not public when an automatic tabulating equipment creates data files? Section 60 specifies that a person participating in the Safe at Home program can participate in the presidential nomination primary. On page 39, section 61 is a new section changing 7 to 14 days. Section 62 is a maintains residency change. In the underlying bill, there is a section about soliciting near the polling place, and that has been deleted and was heard in a different bill. Section 63 changes a cross-reference to, corrects a cross-reference so it's properly referring to the right definition. Section 64 on page 40 is a maintains residency change. And finally, on page 41, section 65 is a maintains residency change.
Mr. Chair.
Senator Anderson.
Back on section 58, it says that once a county has used the electronic voting system, it can no longer change from electronic to hand counting. Is that taking away the county's choice or those that are in charge as far as the county commissioners? And that's either to Ms. Freeman or Senator Westlin.
Ms. Freeman.
Thank you, Mr. Chair. So yes, it would say that once a municipality or a county has made the decision for state elections to go to an electronic voting system, that would remain.
And Mr. Chair,
Senator Anderson.
Ms. Freeman, the reasoning behind that?
The reasoning is, I think, to clarify that that system should be continued. It wouldn't preclude someone from a jurisdiction, if they were eligible to go to a mail balloting precinct, to go to a mail balloting precinct. But it would specify if they had a polling place location in a precinct or precincts that they would continue that electronic voting system use.
So, Mr. Chair and Ms. Freeman, between now and the next election, if new county commissioners came in and by a majority vote decided to go back to hand counting, if this law gets passed, they cannot. Correct?
Ms. Freeman.
Mr. Chair, yes, that would be correct.
Senator Anderson, any follow-up? Thank you. Senator Mitchell.
Thank you, Mr. Chair. Thank you guys for bringing this. I think it'll be very helpful to the process. I do have a question on page 32, 32.24, which is the addition of number 8, that we have to log the number of booths in the precinct on election day. I would just give a friendly suggestion that wherever this ends up going, I would personally find that confusing, because my experience, at least in Washington County, is you're given a pallet with a bunch of supplies. The voting booths are these folded up things that you put up. So let's say you get 16. We almost never put the entire amount up. We usually put however many fit the space. And as the day goes, I've only seen us need more once. Usually we shut some down. So I would just say that unless you have a clarification, it should maybe be clarified as to whether it was how many were delivered, how many were up through the course of the day. You know, if that makes sense, how that might be confusing. Thank you.
Ms. Freeman.
Thank you, Mr. Chair and Senator Mitchell. So this requirement, these two pieces of information are currently required in rule, and are currently on summary statements that come back to us. We are just adding this for clarity into statute, since other portions of the precinct summary statement are listed. And I will say that the wording is based on data that we need to report federally to the Elections Assistance Commission. And so it would, I believe, current guidance that comes from our office and counties and cities and townships would be the number of voting booths used in that precinct on election day.
Ms. Mitchell? Senator Mitchell? Ms. Freeman, does this ignore, for instance, I think in some precincts you use tables so that people can sit at a table and vote, or even curbside voting. So does that need to be reported in this same type of report? Ms. Freeman?
Mr. Chair, sorry, I'm not sure how it works when you're asking the question. I believe that some precinct statements, summary statements may ask for voting surfaces. The federal, like I said, the EAC is asking the state for the number of voting booths. And so if that's what we're wishing to codify today.
Okay, thank you. Okay, Senator Cran.
Thank you, Mr. Chair. So going back to the earlier conversation on resides and/or maintained residence. So when you look through the statute that we're referring to, 200.031, there's a couple things that still, I know resides isn't defined, but at least resides implies you actually live there. And to meet the criteria that you actually live in that residence. Not a technical term, but at least it implies from the average person. You look at number 2 within that statute, and it says an individual does not lose residency if the individual leaves home to live in a temporary or another state or precinct. Okay, so they've continued, they've left, and to me, they no longer reside in that precinct, and when we look at eligibility for candidates and those things, that could be considered a residence. And so it seems like it greatly expands the definition of what we would think where somebody lives versus a residence is maintained. And so to me, we should have more focus and clarity on exactly where somebody lives. And then if you look at number 7, if an individual's family lives in one precinct and the individual lives in another or does business in another, the individual residence is located in the precinct where the individual's family lives. Again, it could be gone for an extended period of time, unless the individual establishes a home or in another precinct, meaning they're still on temporary until they're not. And so you could move away for an extended period of time and easily not meet the filing requirements to be eligible and not reside in a home or live in that home. And so I think the intent is you should be living in that district. So with that, Mr. Chair, I would like to move the A16 amendment to the A15 delete all amendment.
Senator Cran moves the A16 amendment. Perhaps you can explain it while it's being passed.
Thank you, Mr. Chair. I request a roll call as well. So they're passing out. It's very simple, even though the underlying discussion has not made it simple or really clear. Is what it really does is it moves back. It deletes the maintains residence in the reference to the section of law or statute and restores resides. Because at least resides implies that you actually live in that residence, and which you should in order to be eligible to be a candidate in a district. And I would encourage a green vote.
Mr. Chairman. It's me.
Oh.
I was being so quiet.
Senator Westlin, was this amendment shared with you ahead of time? And I guess I'd like to hear what your response is.
So I do not view this as a friendly amendment, and I would oppose it. Going back to Minnesota statute 200.031, which is part of the chapter on elections, specifically defines what qualifies as residents to vote. All we're doing in this language is referring back to the definition of residence. And if one is temporarily away from one's home, but returns and has the intent to return, you don't lose your residence. So I would not agree to making those changes. Again, this is conforming language where we actually have a term defined in statute. And so and it defines what it means to have a residence. So I would not agree to this amendment.
Senator Marty.
Mr. Chair, Senator Coran, the other problem I have with it is the reason for switching it so we have statutory definition is if I rent an apartment or buy a house and I am in there October 1st and then the week before the election, or within 20 days of the election, I am on a vacation. Where am I residing? And I think that's why you have an unclarity with the reside, and that's why maintains residence. I maintain residence, and you got all those provisions on how you define that in statute. It seems to me that you want to have it clear. Does somebody live there? Do they maintain residence? And the word resident resides could mean, well, I didn't reside there every day of that time. So I just think it's clearer to have it follow with the law, the definition we have in law.
Mr. Chair. And Senator Marty,
Senator Cram.
I think with the sections I just read off, I think it doesn't provide the clarity that you believe it does. And it's got a variety. I think there's 12 different criteria in what is, 13 of what is a residence, what is not. But it leaves those open. You could leave for an extended period of time, 6 months. You could be gone for 9 months, 10 months, and technically never reside in the district in which you want to go operate in, because your family maintained a residence or somebody that you're going to declare a residence and then not live there. And to me, I don't think that's the intention. And to me, that just encourages I think we've called it the carpet bagging opportunity. Jump in or jump back into a district hoping to jump on a ballot. So again, I would encourage a yes vote.
Mr. Chairman?
Senator Mitchell.
Could I respond?
Sure. Senator Westlin.
So first of all, we have military personnel who are deployed who are not physically present in the state, but they maintain a residence here. We have individuals who may temporarily, we have snowbirds. And my understanding of the election laws is as long as you are in the state and reside in the state for longer than 6 months, you can vote here. If you go to 200.031, it says, and I can read the whole thing if you'd like, but it says residents shall be determined in accordance with the following principles so far as they may be applicable to the facts of the case. 1, the residence of an individual is in the precinct where the individual's home is located, from which the individual has no present intention of moving, and to which, whenever the individual is absent, the individual intends to return. And then it goes on from there. We have a definition of the term residence. We should use that definition throughout other statutory language rather than coming up with another term that actually doesn't have precision. And so I understand what you're saying. I disagree with it, and I think that we have specific definitions here that actually say this is what qualifies as residence, and we want to make it clear to anyone who has to make this determination. If it says maintains residence, there's a statutory provision they can go to see what that definition is. If we say resides, and there is no statutory definition to turn to, then there is no guidance for the person who has to make that determination.
Senator Mitchell, do you still have a question?
Well, Senator Westlin stole my thunder, but what I was going to say is that I am strongly opposed to this as a member of the military, as someone who has maintained a residence somewhere, my home, that I'm paying a mortgage on and doing everything else on while I have been deployed. While I am deployed, I am residing somewhere else. That is not my home. And this maintained residence is clarifying to me that that is where they consider their home. Same thing with a college student that is off at school, but they still consider their parents' house their home. We let them vote at that address. But especially as a military member, I am deeply opposed to this and the theory that just if someone doesn't happen to be living there at that time, for whatever reason that might even be outside of their control, that we would deny them the right to vote.
Thank you, Senator Mitchell. Roll call request.
Mr. Chair, one quick comment.
No, okay.
Thank you, Mr. Chair. And Senator Mitchell, yeah, I agree with you. Those are called out clearly, right, for military personnel, and that's clear. That example is actually identified and called out. And so to me, the clarity, it doesn't provide the clarity that I think everybody thinks it does. It does call out those various categories, right, the student and those things, but there are also many holes in it where you're not any of those categories, and you can be gone for an extended period of time and still consider some place of residence, and without, with trying to figure out what somebody's intent is to establish new residency. They establish new residency when they file and or own or lease and those types of things. But there's many other areas that you could fall into that category as an adult, not military, not in college, would fall into the no, we don't know where you are, and you do no longer reside in this residence, and then to come back and be eligible to file for office or whatever it is. I think it actually needs more clarity, believe it or not. So thank you,
Mr. Chair. Just to be clear,
Senator
this definition of residence is what we already operate under. This is what we do. And paragraph 2 says individual does not lose residence if the individual leaves home to live temporarily in another state or precinct. An individual does not acquire a residence in any precinct if the individual is living there only temporarily without the intention. Again, there are 13 subparagraphs. That's what we currently do. We aren't changing any of that. We're simply saying that whatever language we use should refer back to the definitions that we are already using. And I guess my suggestion would be if the current statutory definition of 200.031 is not adequate, like that's a separate question and a separate discussion. And certainly if anyone thinks that definition needs to be bolstered in some way, great, just not on this bill.
Thank you. The clerk will take the roll on the A16 amendment.
Senator Carlson.
No.
Senator Westlin.
No.
Senator Curran.
yes.
Senator Anderson.
Yes.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swedzinski.
No.
Senator Dornick.
Yes.
Senator Limmer, absent. Senator Marty. No. Senator Matthews.
Yes.
Senator Mitchell.
No.
Senator Port, absent. Senator Rest.
There being 5 yeses and 7 noes with 2 absent, the amendment is not adopted. Senator Westlin, I believe you have some testifiers, and we would like to make sure that they are limited to 3 minutes each, please.
Mr. Chair, we can do that. We do have 2 friendly amendments, so I don't know if we want to do that
I'm
now
sorry.
or do that later.
Sure. Yes, amendments first. So those are amendments. Senator Bolton.
Thank you, Mr. Chair. I would like to offer the A17 amendment.
Senator Bolden offers the A17 amendment. Perhaps you could, is it something in our packet? It's in our packets. So Senator Bolden.
Thank you, Mr. Chair. Yes, it should be in members' packets. And thank you, Senator Westlin, for bringing this bill. I offer this as a friendly amendment, just to make a small change and clarification, extending the time that folks can return a ballot on Election Day from 3 p.m. to 8 p.m. This offers some clarity for voters and conforms to other times where we end the day at 8 p.m.
Any questions on the amendment? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. The amendment is not, I'm sorry, the amendment is adopted. Senator Bolden.
Thank you, Mr. Chair. I would then like to offer the A18 amendment. which also-
Senator Bolden offers the A18 amendment, and that is in your packet as well. Senator Bolden, can you explain the details of that amendment?
Yes, thank you, Mr. Chair. And again, I offer this as a friendly amendment and a small change so that the persons who have absentee ballots that are rejected, that information is made public. In the spirit of transparency, would offer this small change.
Thank you, Senator Bolden. Senator Westlin, I'm sorry I didn't ask you if you had, that you were in favor of the last amendment. I'm going to ask you now. Do you see this as a friendly amendment?
Yes, Mr. Chair, and we have been in touch regarding this amendment. It is a friendly amendment.
Thank you. All in favor of the A18 amendment, say aye.
Aye.
All opposed, nay. The amendment is adopted.
So, Mr. Chair, at this point,
Senator Westlin.
if it's all right, we could have our testifiers come, now that the bill is sort of in the final form, folks can come up and testify.
Okay, do we have the names of those testifiers? Okay. Gosh, the first one is Ms. Freeman.
Thank you, Mr. Chair and members. I'll be brief. Nicole Freeman, Office of the Secretary of State. Thank you for hearing this bill today. I'm excited to be here to discuss Senate File 1191. The bill is a product that incorporates ideas from several years of work from a variety of stakeholders, including local governments, community partners, and other voters. Included are highly technical changes, small policy changes to expand voter access and improve election administration, and modernization so that statute better reflects how elections are administered in today's world. On the technical front, it makes needed updates to statute due to court decisions and creates continuity and clarity in terminology across election statutes. Beyond the technical components of the bill, it expands voter access by extending the option for local jurisdictions to administer direct balloting, beginning 14 days before the election. Additionally, it expands the deadlines for requesting an agent delivery ballot, as well as for any voter to return their absentee ballot on Election Day. It eases administrative burden and the time crunch for auditors, clerks, and ballot boards by allowing them the opportunity to begin the opening of absentee ballots 14 days before the election. It's been several years since a robust technical or administrative bill has been passed related to election law, and this bill includes several provisions that clarify and update statute to reflect how elections are run today. Thank you, and I will be here for questions.
Thank you, Ms. Freeman. Our next testifier is Mr. Michael Stahlberger, and he's testifying via Zoom. Mr. Stahlberger, please identify yourself for the record and continue with your testimony.
Thank you, Chair Carlson, members of the committee. Good afternoon. I'm Michael Stahlberger. I'm Director of Property and Environmental Resources for Blue Earth County. My department is responsible for administering elections for about 40,000 registered voters, among many other functions. I'm here today, though, on behalf of the Minnesota Association of County Officials. MACO represents all 87 county auditors, treasurers, recorders, and finance officers, and that also includes the county election administrators. In addition, the Association of Minnesota Counties shares our positions as stated in this testimony due to our shared responsibility as it relates to elections administration. MACO's legislative platform and priorities are built on a series of guiding principles. One of those principles is the fair and impartial stewardship of elections. MACO supports legislative efforts that enhance the efficiency, administration, and security of elections statewide. Another one of our principles is respect for local government control, and yet another is continuous improvement for better services. Many of the provisions of Senate File 1191, as amended, furthered these goals and principles for the MACO's membership in our role as administering elections. For that reason, MACO is generally supportive of the bill. To maximize our time, though, I'm going to focus on a few provisions that are of the most importance to MACO. Section 1. We do appreciate the efficiency of having the Secretary of State's office mail out balloting materials to voters in the Safe at Home program. Section 20 is also important to us. We fully support the 14 days of direct balloting as provided in this section. This is a legislative priority for our association, and allowing ballot boards to begin processing but not counting those mail ballots at that 14-day window allows us to respond better to the increased volume, and it also balances the workload for our ballot boards. We also support Section 33, specifically in regards to writing candidates for city and local contests. This will also aid in the speed of reporting election night results. Finally, Section 39 allows for expanded local decision-making and control in designating mail ballot voting. Our association supports that. However, we would further encourage that the registered voter count of 400 be removed as part of the changes made to that section. We also do want to draw attention to Section 59, which is going to add much needed clarification around the availability of textual data, our cast voter records. The text files associated with those will be public with some restrictions, while the images will not be public. This clarification will greatly help elections administrators respond to data requests and allow us to more efficiently share information consistently statewide. I will point out a couple of sections that we do have some concerns with, however. Sections 15 and 16 regarding utility workers and having them be considered deployed for UOCAVA absentee voting processes. This change will need some administrative clarification so that we can be sure that we're determining and applying those criteria adequately and consistently across the state. We also do want to point out Section 21 and the expansion of healthcare facility outreach voting. That is additional workload and cost for our partner city election clerks, and I do believe there will be some testimony regarding that. In closing, we are supportive of Senate File 1191 as amended, and there are provisions that we greatly support. The other provisions do improve the efficiency of the election. We do have some additional suggested changes that were not incorporated in this bill due to some timing and other constraints, and we understand they may be included in other bills. I want to just draw quick attention to those. That includes clarifying the statute that mail ballot precinct voters are given the choice to cast their ballot directly in person at the county's in-person polling place on election day. We also would like to address the writing voter selection and whether or not the oval is filled in as part of that voting selection and how those ballots are counted. And finally, we'd also like to request complete state reimbursement for the presidential nominee. Thank you for the opportunity to speak on behalf of MACO and AMC today. I'll conclude my testimony now, but I am of course available for questions and would be happy to provide that local election administrative perspective. Thank you, Mr. Chair.
Thank you, Mr. Stahlberger, and thank you for the suggestions. And there is going to be some work to incorporate your suggestions in some other bills. So thank you so much. We have another testifier, Elena Niehoff, and you are here in the room. So Ms. Niehoff. And don't forget to sign in before you leave. Thank you. Please identify yourself for the record and continue with your testimony.
Mr. Chair, committee member, my name is Elena Niehoff. I'm from Rochester, Minnesota. I testify in opposition to Bill SF 1191. According to Section 4, Minnesota Statute 2022, Section 201.071, Subdivision 3, deficient registration. B, a voter registration application is not deficient due to any of the following: the absence of the zip code on the application, the absence of the valid Minnesota driver's license number, the absence of valid Minnesota state identification number, the absence of the last 4 digits of voter social security number. If the voter has not been issued one of those numbers and the information can be verified in another government database associated with the application's name and birthday. Here are my questions. How do you plan to secure a Minnesota election if you take away provisions to identify the potential voter by Minnesota driver's license number or Minnesota state identification number or 4-digit of social security number? Next. How do you plan to secure a Minnesota election if you give a permission to verify voter information in another government database by only applicant's name and birthday? Please specify what kind of other government database you have in mind. Next, How do you plan to secure Minnesota elections if you're required to check only voters' names and date of birthday in another government database? Is it enough? Next. Section 4 statute, Minnesota Statute 2022, Section 201.071, Subdivision 3, deficient registration. A voter registration application is not deficient due to any of the following. 2, failure to check the box on the application form that a voter has certified to be the true. If a person has not checked the box and did not certify that all information is true, the person is not liable in the court of law. My question, why do you make the provision to accept a voter registration application from the people who have immunity for liability? We Minnesotans have rights to vote. Government executed among men to secure rights of the people, including rights to have safe election process. I would like to answer for my questions, and also I would like to ask you, please vote no on Bill SF 1191. Thank you.
Mr. Chair,
This is my questions.
just to clarify, there were changes to this, and that entire section you referred to was taken out.
Taken out?
It was deleted.
Okay, entire section?
Yeah.
Okay,
Thank you for your
So
testimony,
your
Ms.
concerns have been addressed. How about that?
Ms.
That was
Diop.
fast.
Okay, thank you.
We anticipated your testimony.
And I
So,
think-
Senator Westlin,
Oh, okay.
perhaps you could repeat that into the microphone.
I'm so sorry, Mr. Chair. So the section referenced was in an earlier iteration of this, and it was removed. So that entire section does not appear in the bill as amended.
Thank you, Senator Westlin. Okay, I have another person on our list, Ms. Lily Sass. Please identify yourself for the record. Don't forget to sign in, and proceed with your testimony.
Sure. Chair Carlson, Vice Chair Westlin, and members of the committee, my name is Lily Sassy, and I am the director of We Choose Us, a coalition of 30 organizations and growing across the state of Minnesota who are committed to building a multiracial democracy that truly and meaningfully puts people at the center. Our coalition is made up of a variety of different organizations, from unions to grassroots organizations and advocacy groups to good governance organizations, many with large membership bases, and all of whom have been working to improve our democracy and bring more people into the process for years, for some, even decades. While our elections are safe and secure, free and fair, to be sure, we still have improvements we can make. Since the launch of our effort, we have built relationships with many, many Minnesotans through our partner organizations, but also through intentional outreach to all corners of the state. We held listening sessions, public feedback forums, and surveys for voters to respond authentically to the things they want to see improved, the things that would directly impact them. We heard things from people about making voting more accessible to folks living in hospitals and assisted living facilities, the desire to be able to return absentee ballots until polls close on election day, the assurance of assistance in polling places for folks with disabilities, and fears about the challenges to voters happening in other states, and a desire to ensure that doesn't happen here. Our goal is to ensure we have an easy-to-understand, streamlined elections process that provides options for voters, rather than further barriers or confusing hoops to jump through. This bill offers many provisions to do that. We encourage a yes vote and look forward to working with you to protect and expand our democracy. Thank you.
Thank you, Ms. Sassy. And I believe that we skipped over one testifier, Mr. Alex Hassel from the League of Minnesota Cities. Oh, Ms. Alex Hassel from the League of Minnesota Cities, yes. Please identify yourself for the record and continue with your testimony, not forgetting to sign in to the testifier log.
Thank you, Mr. Chair and members. My name is Alex Hassel. I'm here on behalf of the League of Minnesota Cities, representing 837 cities across the state. Mr. Stahlberger did a great job covering some of the provisions that the league also does support, so I don't want to be too duplicative, but I want to mention a few of the items that the league has long supported to help improve the administration of elections in our cities. As the county has mentioned, the league supports the expanded direct absentee voting timeline from 7 to 14 days as well. We also support Section 33 regarding write-in candidates. Currently, city election officials spend considerable time and resources to count individually and record write-in votes cast, many of which are non-serious. This would eliminate some of that unnecessary work while still ensuring that legitimate write-in candidate votes are still counted. We support Section 36 regarding the passing of an ordinance or resolution for the changing of polling places. For many of our cities, polling places don't change from year to year, so we see it as unnecessary to have to pass a resolution every year, so we support this provision as well. The league also supports the authorization of mail balloting in Section 39 to metro jurisdictions, and we appreciate that being included in the bill. I would like to mention one provision that we are still looking into to understand the full impacts of, which is the expansion of healthcare facility voting. This would be an expansion of what our cities currently are required to do, and it's not quite yet fully clear how cities will be able to verify all of these facilities in which they are required to serve under the provision. But we've shared that with the author and look forward to continuing to work on that provision. That being said, we appreciate many of the items in this bill, and I will leave it at that. Thank you.
Thank you, Ms. Hassel. We're at the point where if we have any other amendments, Senator
Mr.
Grant.
Chair, I do have a question on, so if you go to Section 39, and it really refers to the change in expanding, I think the intention is a township of any size, not limited to the 400 residents of voters, and it looks like it expands to a city or a city having fewer than 400 residents. If you go to 28, that 17 and 18. Should that be a township? I don't want to get tied up too much into semantics, but I assume the intention is still of that change is a small city or a township, and we just got rid of the metropolitan area boundary. Should it say township? Town, city, they can be used synonymous, but it doesn't imply a township.
Ms. Freeman.
Thank you, Mr. Chair. I think I would, that is what it is in current statute, and so I think I would defer to Ms. Stengel for an opinion on what word would be the most appropriate.
We will take a minute and circle back. Senator Grant, where are you thinking that word might be?
It's Section 39, Subdivision 1, page 28, line 17. And I see it is existing, yes, but I think if, from a clarification perspective, town, city can be used synonymous.
Ms. Stengel will help us with this.
Yeah.
Ms. Stengel.
Thank you, Mr. Chair and members. Town is the proper term when we're talking about like the local unit of government, and township is what we refer to when we're talking about the geographical area. They're usually like the square grid, but not always. So I think town is the appropriate use here because we're talking about the local unit of government.
Thank you, Ms.
Senator
Stengel.
Grant, good with that. Any other questions?
Mr. Chair.
Senator Grant.
I do have one comment as it relates to the voter assist, right? The current, the proposal removes the limit to assist 3 people, or the previous statute limited to 3 in this bill changes that to an unlimited number. And I thought we fought for secrecy and we want to provide assistance where necessary. And I see very little need to move beyond the current 3-person limit. And so, Mr. Chair, I'd like to move the A19 amendment to the underlying A15 amendment to this bill.
Senator Cran moves the A19 amendment. Could you explain the amendment while it's being passed out, Senator Cran?
Mr. Chair, and this one's pretty simple. It just restores the 3-person limit on the and restores it back to the original. I request a roll call.
And that's on, Senator Cran, that's on page 32, and it's section 44.
Mr. Chair, you are correct.
Senator Westlin.
Mr. Chair.
Wait.
Senator Cran, I'm looking at page 32, and section 44 is about information requirements, so I'm wondering if maybe this was based on the prior iteration.
Our
Can you-
Eagle Eye counsel has caught an error that she'll help us correct.
Great,
were
so
provided
I'm
with
not
the wrong
going
section.
crazy. Got it, okay.
Mr. Chair and members, I think the easiest thing to do, if I can offer a suggestion, is for Senator Corran to withdraw the A19 and make an oral amendment to delete section 43 on page 31.
Senator Grant.
Thank you, Ms. Stango, and I will withdraw the A19 amendment.
Senator Grant withdraws the A19 amendment.
And make an oral amendment on page 31, delete section 43. And I encourage an enthusiastic yes vote.
Mr. Chair, Senator, so actually the language that
Senator
was.
Westlin.
I'm sorry, Mr. Chair, stepping all over your line. So actually, this language change was related to a consent decree and an order from the Minnesota Supreme Court in 2020 that deemed those prohibitions were a violation of the Voting Rights Act. And so for those reasons, I believe your amendment would actually run afoul of that consent decree and that order from the Supreme Court.
Senator Cran, you requested a roll call? Yes.
I will encourage members to vote no.
Any questions on the amendment? Senator Anderson, did you have a question? No.
Senator Carlson.
Yes, clerk will take the roll.
Senator Carlson.
No.
Senator Westlin.
No.
Senator Corran.
Yes.
Senator Anderson.
Yes.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swedzinski.
No.
Senator Dornick. Senator Limmer, absent. Senator Marty. No. Senator Matthews. Senator Mitchell.
No.
Senator Port, absent. Senator Rest.
There being 5 ayes, 7 noes, and 2 absent, the amendment is not adopted. Senator Westlin. We have another question here. Senator Matthews.
Thank you, Mr. Chair. I'd like to make an oral amendment on the A15 amendment, page 16, delete section 23. Mr. President, or Mr. Chair, this section is on agent delivery of ballots and is proposing to extend the time from 2 p.m. on Election Day all the way to 8 p.m. on Election Day. And Mr. President, or Mr. Chair, I'm finding myself on the Senate floor, unfortunately, here in committee. Mr. Chair, it's difficult to imagine when you have the entire period of time, the 7 days preceding the election, why a need for the hours of 2:01 p.m. through 8 p.m. would be necessary, where that's the only available option. An agent delivery of ballots gives that time gives the election judges or that jurisdiction time to verify the information that they've been given. Otherwise, we're going to have here where an agent could arrive at 7:59 p.m. and say, I'm an agent and here's a ballot and now it's time to count, and does not provide that that time period for verification. And we've had instances in Minnesota recently where someone came in delivering ballots, and then after the fact, voters were contacted, found out about that, and said, no, I did not authorize that ballot or that delivery. And so my oral amendment is a simple step towards openness and transparency, making sure that we have as much credibility and integrity in our election system as possible. We have a full 7 days, and then we have the time period of that afternoon to make sure that the information is verified. And so I would ask members to vote yes on my oral amendment.
Thank you. Senator Matthews initiated an oral amendment to delete subdivision 4 on page 16. Senator Bolton.
Thank you, Mr. Chair. I would encourage members to vote no on this oral amendment. Not everything can be planned for, and so people on election day may become suddenly ill, may need to have emergency surgery, may be hospitalized. There's a number of things that cannot be planned for that this provision would allow those people's votes to still count, to allow them to still be able to cast a vote, and that is important. So I would encourage members to vote no.
Senator Westlin, was this amendment covered with you?
No, Mr. Chair, it wasn't, and this is not a friendly amendment, and not a friendly amendment, and I would ask members to vote no.
Mr. Chair.
Senator Matthews.
I'd like to request a roll call. Obviously,
Roll call
this is an oral.
requested. Roll call granted.
Thank you, Mr. Chair. Obviously, it's an oral amendment after going through the presentation of this amendment that was just given to us here in committee. And we have to balance the accessibility as well as the integrity. And so I understand the questions that are provided, but there is a myriad of other options that are already there. And if you're in a situation such as described by Senator Bolden, then it's very unlikely that you're going to be able to have a ballot filled out and fill out the proper procedure and have that sent with an agent anyways. So let's not let the excuse of what we can consider as an excuse get in the way of having a strong election integrity system here in Minnesota. This is a reasonable backdrop that's been in law before, so that we have the process for verifying these ballots that are delivered in this manner. So would urge members to vote yes.
Mr. Chair, so just to be clear, thank you, Mr. Chair. So the language is already in statute. It already allows for these scenarios, and all it is doing is simply expanding the time for those ballots to be returned so that people who had intended to vote in person on Election Day are not denied the opportunity to vote. And just to clarify also, I understand that everyone got this amendment today, but we did everything that we could to try to get these things to folks in advance. We're not required to do that. I literally could have dumped all of this on you today, and we did try to get language out to all of our members as soon as possible so that you could see what we were doing. And so, again, I would just encourage everyone to vote no on the oral amendment.
Call has been requested on the Matthews oral amendment. The CLA will take the roll.
Senator Carlson.
No.
Senator Westlin.
No.
Senator Karan.
Yes.
Senator Anderson.
Yes.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swedzinski.
No.
Senator Dornick.
Yes.
Senator Limmer, absent. Senator Marty.
No.
Senator Matthews.
Yes.
Senator Mitchell.
No.
Senator Port, absent. Senator Rest.
There being 5 yeses and 7 noes and 2 absent on the Matthews Amendment, the amendment is not adopted. Are there any other amendments?
Mr.
Senator
Chair, I'd like to move the bill.
Senator Westlin moves the 1191, Senate File 1191, and forward it to Judiciary
As amended.
as amended.
Mr. Chair, I'd like to have a roll call.
Senator Anderson, thank you. Roll call requested, roll call granted. The clerk will take the roll.
Senator Carlson,
Yes.
Senator Westlin,
Yes.
Senator Karan,
No.
Senator Anderson,
No.
Senator Barr,
Nope.
Senator Bolden,
Yes.
Senator Swedzinski,
Yes.
Senator Dornick,
No.
Senator Limmer, absent, Senator Marty,
Yes.
Senator Matthews,
No.
Senator Mitchell,
Yes.
Senator Port, absent, Senator Rust,
There being 7 yeses and 5 noes and 2 absentees, Senate File 1191 is adopted and sent to Judiciary. So, Senator Westlin, I'm going to disappoint you.
Mr. Chairman, I heard,
Yes.
and I am deeply disappointed.
We have one of the simplest bills that our Senate Council put together, but unbelievably, we found a small error in it that needs to be addressed, and so we are continuing that bill to another committee meeting. So that being the extent of our work today, the committee is adjourned.